Welcome to the Expert Witness Club webinar series. I'm your host, Noah Ballmer. Today's webinar is From Summary to Interview, How Experts Can Align Their CV and Expertise to Win Engagements. Our guest today is Monica Poole, Director of Expert Witness Services at Roundtable Group. With that, I'll turn the show over to Monica. Welcome.
I'll just introduce myself. My current role is I'm the Director of Expert Witness Services at Roundtable Group, but I've been in the legal industry for a few decades. I started out practicing law as a tax attorney, and that was a little bit too much of a snoozeville for me. So I went into technology at Thomson Reuters, which was called West Publishing. And I started working with the various online legal information products. And I worked very closely with law firms, with their associates, with partners, with government agencies, with law students, pretty much corporate departments. And it was all about how they researched, how they answered their legal queries, and also how they found experts. And then that led me to the Roundtable Group, which was at one time part of Thomson Reuters, but our owners purchased us, and we are now back with Roundtable Group, which has been around for a long time. We're very fortunate to have our original owners who sold us to Thomson Reuters purchase us back. Basically, who I am and my background, and I've been with Roundtable Group probably I think it's 12 years now, but it's been definitely a long time. And I've put together this presentation because a lot of times I'll have experts call me and say, "What can I do better?" And so this is based on my knowledge from the last over the decades of what attorneys are looking for, how you can kind of get a perspective from their eyes, what they're seeking, how you can put your best foot forward, remembering that there's so much outside your control. So even if you are perfect, respond perfectly, interviews perfectly, you still may not get hired because the client may have a best buddy that they want to hire. The case may settle. There's a lot of different factors that will happen. But hopefully, this will give you some ideas of how you can put your best foot forward and increase your probability of being hired. So, the first thing I want to address is when you get an inquiry, whether an attorney calls you directly, whether you get an email from a search firm, you have to make a determination whether this case or this issue or this type of expertise squarely fits within your wheelhouse. This is extremely important because you want a long career as an expert witness. At some point, you're going to be challenged. If it's federal court, it's a Dalbert challenge. If it's a state court, it could be a Fry motion. Some way, they're going to challenge you. And if you are trying to fit your expertise in something that really isn't squarely what you do and you do get disqualified, it's not the end of the world, but it's something you're going to have to explain away at every interview. The other thing is you're going to have to consider about business complex. For example, let's say you're in the waste management industry and your clients are landfills and you work with cities. And this case comes around and it's for a major city and they want someone to go against that city. It may be a business conflict for you. And if you take this case and you're going against some of your biggest clients, is that going to prevent you from getting your consulting business in the future? So there's a lot of things you have to sit back and think about. And you may not have all the information at the very beginning. So you might want to go ahead and reply and get more information. But these are things to think of throughout the process. Before you accept, you want to always keep this in mind. Is this squarely within your wheelhouse? Is there any chance, is there any argument that you can see that you'd be disqualified? And if it is, discuss it with the attorney that you're talking to, and then think about business conflicts as well. I have a lot of experts when they're asked by an attorney, have you ever been Daubert? And they're like, I don't know what that is. It's just the name of a case, and it applies to federal cases. So if you do mostly state cases, you may never hear the word Daubert, but there are state cases That it's basically trying to prevent you from testifying. The bottom line is they're trying to say that you don't have the right expertise to give this opinion. And we actually have a WebEx that was done a couple of weeks ago that was excellent, that was all about Dalbert motion and then the Fry motion, which applies to state courts. So if you didn't see that, definitely check it out in the library because it was an excellent presentation. So this is a summary here. Again, I just discussed, federal courts is called Dalbert. State court is not uniformed. But every state has some type of procedure to exclude experts, and this is really common now. Don't take it personally if a motion's filed to exclude you because it's a strategy that is done all the time. So that's why again it's very important that you think about this throughout the entire process. Getting selected as an expert is a two-way street. You are interviewing the firm and you have things to think about, not just, I want the job. You have to think if it's the right fit or not. We talked about assessing your fit, presenting your qualifications, responding to the attorney's industry, inquiry. You have to make sure your expertise aligns with what they're seeking. And sometimes if you get a phone call directly from the attorney, oh, we need a mechanical engineer. So one of the questions you need to ask back is, okay, what issues do you want your expert to opine on? And that way you can really see if you're comfortable opining on those issues. And then the next question should be, well, okay, I believe I have the expertise to opine on that issue, but do you have this record? Do you have that record? Do you have the materials that you would need to make a determination? So that's the other question you need to ask. What is available for you to base your opinion on? You also have to look at, the plaintiff versus defense. You are hired as an independent expert. You need to make an independent determination. But if you strongly feel that you don't want to get involved in this case, maybe for a political reason, or it doesn't fit your values, that's another thing you have to consider as well. So once you decide, yes, this looks like a really good opportunity, I want to go for it. This is a little secret that is very helpful for attorneys. They're going to get your CV and spend maybe 10 seconds, 20 seconds looking at your CV. So this is a little trick that one of my attorneys actually taught me, especially for if you have a CV that is 5, 6 pages or 20 pages or 30 pages, highlight the most relevant. He likes the top 10, maybe the top 3, the top 4 in your CV that relates to this particular issue. That makes the life of the attorney so much easier. If you get a description and it says, I want someone who was a former CFO at a public company, and you were a former CFO at a public company, definitely tell about that experience. Maybe you weren't a former CFO, but you were called, the finance director. Say, I was a finance director and these were my responsibilities and list it out. Generic bios, I understand they're easy and you aren't being paid at this time. It's an interview process or a process, but they lower your chances of getting that interview. If you actually spend a few minutes responding to the inquiry with your expertise, tailoring the response, and then spend a few minutes highlighting what's important in your CV, it will definitely increase your chance of moving to the next stage, which is the interview stage. We talked about reading what the search requirements are. They're usually going to tell you we're seeking an expert in glass manufacturing and someone that works with a material, and it may be a material engineer that has worked in a laboratory that knows about the strengths of the glass. And those are the things that you can address from your background. The other thing I want to encourage you to do, especially if you're a new expert, maintain a very detailed case list. This is more for your reference because some of the things that they will ask you for at some point is, have you ever testified in Delaware under a certain judge? And if you don't have those details, it's really hard to create that information. Do the case style where the court is from, what judge it was, what you did. Did you write a report, or did you write the report and you were deposed? Did you testify? Just a really short, generic sentence about the cause of action and what you maybe a line about what you opined on, and then the results. Did you win? Did you lose? Well, what happened? Was it settled? And that way, when you get those questions that say, I'm looking for someone that has prior experience in front of Judge Bloom, you can quickly reference your list and see it. Also, that saves time if you have a detailed list that has that information and you send it to the attorney. uh, they're going to spend time pulling every case on your CV. So if you already make their life a little bit easier, they know what the outcome was, they know the judge, they know the issue, they know what you opined on. It just increases your relevancy and it makes your beacon, hire me beacon, shine a bit brighter.
Monica, for the purposes of these lists, is there a preferred format for that? For sending them off, should they be just a text document or should they be kept in a spreadsheet or something searchable? What's the best way to maintain that sort of a list, especially for more experienced experts that might have, dozens or hundreds of cases?
I would say what's easiest for that expert. So if an Excel sheet is easier so they can sort, that would be fine. At the beginning, you can just keep a Word document. So I don't really think it matters as long as it's a common file, like a Word or an Excel that you can pass on to the attorney. What happens if you lack testifying experience? This is very common that, especially for large litigation cases, they want someone that has testified before, and sometimes they want someone that has testified like at least 5 times, not just once or twice. But it's really hard to get testifying experience because a high percentage of cases settle right after the report stage. If you haven't testified, first of all, deposition is considered testifying. So definitely list how many times you've been deposed, even if you've never made it to trial. That is considered testifying experience. Um, but if you haven't even done that, you've just written reports and everything has settled, or you're brand new, try to get some public speaking experience. If you teach any courses as an adjunct professor, highlight that. Speaking at associations, a great way to get jobs is speaking at a local bar association, just so you can list that you have experience in front of the public speaking and clearly defining complex terms. That's why teachers are very well sought out of academic professors, because they're used to explaining complex terms. I've even had attorneys ask for professors to say, well, okay, you teach this course all about paper materials. What are some of the materials that you've put together that conveys this concept of material of paper? And they have asked them, share those type of documents. So that's another thing, keep track of your publications, even any articles you've written for a trade show. Just have all that listed so you can easily access it, because you really don't know what they're going to ask. So if you have everything organized that you've done that you can quickly grab, that makes it better for the future. Your rates retainers, the simpler the better. If you don't have any testifying experience, don't uptick your rate, because you want to gain that testifying experience. So make it as easy as possible. Travel is, try to discount that. 50% is the norm of your hourly rate. If you want to, you could waive travel. Some people do that. That's totally up to you, but just keep it simple. Don't make it complex. The other thing about retainers, I think it's best just to wait until the interview process and see who the client is, see who the law firm is, how big is the case, how much time it's going to take, and then discuss the retainer amount. I think it's better to wait till the end and just reply, I may or may not have retainer, is to be determined on the situation. Okay, preparing for the interview. You may or may not receive the complaint. If you receive the complaint, spend a minimum of 15 minutes reviewing that complaint. You want high level understanding of the issues. If you do not receive the complaint, then the most likely the attorney would like to tell you the story of his case or her case the way they want you to hear it. They may be seeking an expert, especially if they're in the defense, that isn't going to be evident by the complaint. So if you read the complaint, it's just going to confuse you because they have come up with a strategy that needs a particular expert that the other side may not be presenting or may not be evident by the complaint. So if you get the complaint, definitely spend 15 minutes understanding high level. If you don't get the complaint, don't spend a ton of time trying to research it and figuring out what it's all about because most likely the attorney wants to tell you the story and to let them tell you the story. Review your CV because m- mostly I'm going to go through what's going to happen at a particular interview. They are going to ask you questions. Some attorneys literally will go start with your education and go step by step through your CV. Others may just ask you a particular question about a job. Tell me what happened. What was your role at company ABC? They may not spend a lot of time, but you can pretty easily tell the attorneys, the experts that know their CV inside and out, and the experts that haven't looked at it for a few years. So just, take a 5 minutes beforehand and just refresh your memory about, your current CV, what's on there. Because you most likely, you definitely, I would say it's 100%, you're going to get some question about your CV. And it'd be nice to have that fresh in your mind. And then also remember that they're evaluating your communication skills. So, especially if the case is going to be in front of a jury, they're looking for someone that is likable, that has energy level. So, you want to, have a certain amount of energy, be pleasant. You want to be easy to understand, and then have an example ready from the past where you've had to explain a complex idea in simple terms. So if they ask you, especially it would determining the case, like for example, how do you explain what an algorithm is? One of the attorneys that I said, well, an algorithm is basically like doing your taxes. You have a bunch of rules and you have to apply those rules to get an outcome. And that's what an algorithm is doing behind the scenes, applying a bunch of rules and spitting out an outcome. And that was this particular expert's example of how he explained a complex term easy to a jury for a jury to understand. Okay, so this is basically what happens at every interview. It's a formula. So you can expect at the very beginning, first of all, the attorneys want to see you. They want an expert. So they are looking forward to this meeting. They'll introduce themselves. Usually one person will be the speaker. Sometimes it's the partner and that is the main decision maker. Sometimes it's the young associate who's getting experience interviewing experts, but the partner most likely will be on. Sometimes you'll have a two-step process in the interview. You'll have a initial interview that's kind of a weeding out interview, and then that would be maybe with the associate or two or three associates. And then there might be a second interview with the final candidates that will be with the entire litigation team. And I've seen up to 5 or 6 attorneys on a litigation team interviewing the final candidate. Sometimes the client is also on the final interview and is asking questions directly to you. So they'll introduce themselves. They'll ask if they've supplied the complaint. They're going to ask you if you've read it. And so that's a yes or no question. Then they will say, well, let me just give you a high level summary and what we're seeking. So even though you've read the complaint, they'll probably summarize the issues that are most important to them and the issues that they're actually seeking an expert on. Then they're going to turn it over to you. And that's where your prep work is going to be good. So you can point out in your, from your experience. But actually, before I get there, a lot of times the attorneys will ask you to summarize your background. Don't assume that every attorney on the call has read your CV. Maybe just the initial associate read it. Maybe just the partner reviewed it for a few minutes. And there could be other attorneys on that call that have never even seen your CV. So if they ask you to just briefly summarize your background, keep that in mind that they might not have looked at your CV. To start with your education, that you're a PhD, that you have a master's, and actually talk about your most relevant experience to the issue. And they're going to talk back and forth. That's when they're trying to determine whether or not you have the right expertise for this particular issue. After the back and forth phase, the next thing is that they will talk about your expert witness experience. So they will want to know how many reports you've done, how many depositions you've done, how many times you testified in court. And that's where those lists are very helpful to you. So if you supply them ahead of time, that's even better, right? And then finally, the final part of the interview will be the timeline, when they will make a decision, when deposition reports are due, when the deposition's due, and the trial. So there's 4 parts of an interview: the background of the case, your background and how it fits the case, your experience as an expert, and then the timeline. So those are the 4 parts of every interview, and that is the formula for 90% of interviews. There are some interviews that go a little bit off course, but most of the times that's the course that you can expect. Those 4 things. Now, this is a very Noah actually asked me to split this slide up, but I decided against it because these are some common questions that you have a high chance of being asked at an interview. So I wanted to just, we talked about your background and how it relates to the case. That's just going to be a given. The documents you would need to review, we talked about that. So think about that beforehand, especially if you already know what you're supposed to opine on. Like, what documents would you need to answer that question? We talked about your case list, how many reports you've written, depositions, trial testimony. A lot of times they'll ask you what the outcome is. They'll say, have you ever testified or opined or written a report or been an expert in a case on a similar issue? And then you elaborate on that. And then they will ask you what you did on that case, whether you wrote the report or deposed, and then they would ask you the outcome. What percentage of cases are plaintiff versus defense that you do? That sometimes, if it's important, they'll ask you that question. They're trying not to hire what's referred to in the industry as a hired gun. So they may ask you 100% of your work is expert witness, or do you do other types of work? What percentage of your income is derived from the expert witness work? In cases, for example, damages cases, pretty much all experts, that's what all they do. So this question doesn't apply to every single case, but sometimes if it's important, they'll ask this question. And then number 7 is what we talked about at the very beginning. Has your testimony or opinion ever been limited or excluded? And if your answer is yes, then you need to be prepared to give them the case and let them know what happened and explain it away. So that's why at the very beginning of this, we discussed try your best not to get involved with a case that exposes you the possibility of being excluded. And then, they're also going to ask, is there anything in your background they need to be aware of? Have you had a malpractice case against you? Um, I had a situation where an expert was hired and he had a identity theft allegation against him. It hadn't been proven yet, but he was being hired for a security issue. The attorney wanted to hire him and then ended up backing out. Social media account, you want to, that's public, so they can search it. They can see what you've written. This is your career, so just make sure it reflects the person you want to your brand. Make sure all your social media posts presents whatever brand you're trying to present yourself as. And then, of course, the publications we've talked about and how it's important. The reason why they want the publications is if you've written anything out there that can be damaging to their client, they want to make sure they know about it so they can either address it for damage control or um, they'll see what the other side will see and see if it is going to be an issue. And then sometimes if you do have a report that you've done that you may want to just ask, hey, can I redact all the names and use this as an example of my work for future cases? It, or, the attorneys can just try to find some public reports that you've written. They are out there and easily accessible. But if you have a few examples that you can pull from, that is very nice. And same as depositions. If there's ever some deposition that you can keep that the attorney gives you permission to use, I would definitely redact names for privacy concerns. But that's nice just to have in your pocket in case you're ever asked. And then this is also more common attorney references, especially for cases that are similar to their own. If you have done a case that's very similar, they probably will ask the law firm, they probably will ask the attorneys, and if they can contact those attorneys. Okay, so this is the perspective what they're looking for, from their side. They want strong, relevant expertise, of course. The communication style, they're looking at you like they're trying to determine how you would act at a deposition. Are you going to excessively talk? They're going to kind of gauge the way you answer your questions in the interview, how you're going to be deposed. Um, so just think about that because they're looking at communication styles. Are you easy to understand? They may even ask for you to give an example of explaining a complex topic if that's important to the presentation. They definitely would want a teaching presentation style. I do have an expert who's great at presenting that was never a teacher, that was always in the industry. And he actually highlights that. He says, listen, my presentations were to customers, to colleagues, to trade shows. I've never been a professor. Um, all my experience is industry, industry, industry. And he highlights that to distinguish himself from others. And he does a great job in his presentation. So I'm not saying you have to be a teacher. Just make sure that your presentation style is confident, energetic, and clearly distinguishable, used to distinguish that you can clearly answer questions without oversharing. Again, if you overtalk, if you talk too much, if you try to step outside your lane, remember you're hired as an expert in your expertise. You're not the lawyer, even if you've done this, so many times. I would not get into legal strategy unless they specifically ask you. Some of my seasoned experts that have done this over and over, the attorneys may say, have you seen this strategy before? And they may ask about it, but I wouldn't volunteer it until I'm asked because one of the things is experts who try to play lawyers, they get on the attorney's nerves basically because that is the attorney's job. You also as an expert only know what you're told for your role. You don't have a 360-degree picture of what's going on in the case. So your what you think is the best strategy may work in your world, but when you take into account the entire case, it may not work. So keep that in mind that you just know your lane. You don't know the 360-degree issues, all the issues going on, and all the different topics going on. Make sure you stay on topic and not go down a rabbit trail. I wouldn't really come prepared to ask questions. I would wait to see what the questions are for you and answer those questions. And then if you have questions based on those questions, ask them. But usually when an expert comes saying, I have these questions, I know they're trying to show that they've done their homework beforehand, but sometimes it's off topic for what the expert wants, what the attorney wants to hear from the expert. And again, presentation style. If you ever have the experience to go in front of a mock jury or even volunteer to be the expert at a training program, excellent experience, especially for new experts. any type of training, even doing a presentation in front of your family and asking for feedback, or friends or colleagues. You may present in a style that you think is great, but then a third party watching you may have some very constructive feedback for you. Closing the interview. So if they don't, hopefully they tell you the timeline. If they tell you the timeline, that's almost like, when you're on a job interview and it goes really well and you have a great rapport and they give you a tour of the office. That's when you know, okay, I'm probably going to get an offer. When they tell you the timeline and the decision making process, and they're like, we're really interested, we're going to talk to our client, we're going to get back in 2 weeks, we want to make sure you're available for the reports in 2 months, the deposition, the reports due May 31st, the deposition's in June, the trial is July. Do you have any conflicts? Do you have any time that you're going to be out of the country? Those are really positive signs at the end. If they but sometimes they run out of time, and they may, or it might be an inexperienced person interviewing you and they don't talk about the timeline. So this is your chance to ask, hey, when are you guys making a decision? Are there any dates I need to look at my calendar to see if I'm clear? Those are great ending questions. Also, the retention time varies. Sometimes they're really early in the process, so they may not have a calendar. They may not have the dates to give you. And that's also good to know. Okay, they're early in the process. They're not going to make a decision next couple weeks. I'm just going to put this aside. I may hear from them in a couple months. It's good to ask that question, and whether they can answer it or not, you will learn more about where they are in their decision making factor. There's so many things outside your control, so just because you didn't get an expert assignment doesn't mean you weren't qualified, doesn't mean you didn't interview well. It just means, something happened that was outside your control and somebody else was selected. It could be an expert that was nearer to the jurisdiction. It could be something like maybe you were equal, but they were in the home state and you were in the neighboring state, and that was just a little bit more of an edge to make the difference. I would never worry if you didn't get an assignment. Just keep plugging along. And this is a statistical process, so the more you apply, the more you interview, the better you get, the more you learn, the higher probability you're going to get retained. And once you get retained, it's going to be easier to get retained again.
Thank you, Monica. This brings us to the Q&A portion of the show. I posted in chat that conflicts can arise at later points, for example, in
Mhm.
mergers, joint cases, acquisitions, etc. What do you think about that?
Yep, absolutely. And so as soon as a conflict arises, you should contact the attorney and discuss it. So as soon as you realize, um, yes, we've had situations, especially if the expert witness process is long. I just had one that was 10 months long. Um, things can happen in 10 months. Mergers can happen. You might meet someone, you might have an opportunity. So just bring it up whenever you realize there is a potential conflict.
Our next question. Once an expert gets to the interview stage, how much does alignment between their CV and how they speak about their experience matter?
I think it needs to match fairly closely because, you know, if it doesn't match closely, that actually will open up an opportunity for the other opposing counsel to attack them. So I think it needs to match very closely because you're giving the other side the CV as the credentials of who you are. And then if you're being deposed and you state something that differs from your CV, that opens up a can of worms and an opportunity for the other side to attack your credibility.
What's one of the way experts can pressure test whether their summary is truly supported by their CV before submitting it?
If they're comfortable using an AI tool like Copilot, they can write their summary and ask Copilot to look at their CV and see if their CV backs up their summary. Some people are not comfortable with AI tools. So, what you may want to do is give it to a colleague, your CV, and say, "This is my statement," and ask your colleague whether or not they feel like your CV backs up your statement.
In any case, you should probably be doing it before you submit it to an engaging attorney, right?
Right, definitely. And the other thing is maybe your current CV doesn't back up your summary because you have done so much in your life that you don't have everything on your CV. So maybe you should tailor that CV to show the experience that's most relevant to that particular case and just customize the CV so it doesn't back up your summary.
Next question. If you had 30 seconds to scan an expert's CV, what are the top two or three things you're looking for to decide if they're worth interviewing in the first place?
Well, that depends on the issue you want them to opine. So, for example, if it's some technical issue, um, I had an attorney. I thought it was a technical issue. The expert had the technical background, but didn't have an educational PhD in that background, and so she refused. She didn't refuse. She declined to interview him because he didn't have a PhD in a technical field. So I think they're going to look at your education, and they're going to look at whatever buzzwords they think are important. For example, that prior experience as a CFO in a public company, if that's really important, and that they're going to look for that first. So I think your clue is to look at your search intro and pull out the top two or three requirements of that search intro, and then make sure those are highlighted in your CV.
What's one section of the CV that experts consistently underutilize, but could actually make them stand out more to attorneys?
I think definitely public speaking engagements may not be on there as much as they should be. Um, Also, actually, a description of what they did at their prior job that actually that makes that's tangible. Not like, oh, I visited clients, but what did you do? What software did you work with? What were you responsible for? So look at your descriptions, job descriptions, and see if it at a high level will tell someone what your responsibility was.
Is there ever a risk of putting too much into a CV where it becomes overly long? You say that a lot of attorneys don't spend a whole lot of time reading these or some limited amount of time. What's the inherent push pull, and how do you deal with, well, should I really put in this section that might be kind of interesting, but not necessarily? How do you manage that?
Well, the old basically the older you are, the longer your CV, right?
Right.
And then also if you're an academic professor, they're very long as well. Um, so you may want to have a short version of your CV that especially if it's not for your academic CVs when you're going for another professorship job is extremely long. So maybe you may want to have an expert witness CV that's more tailored. It's hard because publications are important, and so you do want to list all your publications because you don't know what the topic's going to be. So that's why if you could take your long CV and highlight the top 10, it would help you.
Another comment, materials supplied to counsel are likely discoverable. Be careful about internal notes.
Yep, and that's something you need to discuss with the attorney on the jurisdiction. So it depends on what state, and if you're in state court or federal court, whether emails are discoverable, whether they prefer everything by phone, are notes, drafts discoverable. All those questions you need as soon as you become an expert for that a particular attorney, or if it's relevant on the interview, bring it up. But yes, that's an excellent observation. You do need to understand from the very beginning of your assignment what's discoverable and what is not discoverable.
Perhaps you've You've explicated this already, but when it comes to standing out from the crowd in competitive, potentially lucrative searches,
Mhm.
how important is specificity, like naming industries, case types, or methodologies versus keeping things broader? Or other tips on that front?
I think naming is important, especially, if it's a technology case and you've represented Apple, you've been an expert witness for Apple or Microsoft or Google. I think that's very relevant. Um, if you worked for well-known companies, make sure that's on there as well. Methodologies, there's different methodologies out there, so maybe that's something you hold back on the interview and hear what methodology they're interested in, and then be ready to answer the question on that part. As long I mean, I've worked, I've been, especially in the recent months, um, I will push back if I receive an expert summary I don't feel like answers the question. And if I work with the expert and I get the questions answered and the CV backs up their statement, I mean, I don't want to say guarantee, but it's a very high probability they're going to get an interview. And then once you get that interview, that's the time you can't put everything on a CV. So that's when you see really what they're interested in, and you take that time to highlight, name drop, you talk about your industry, and you talk about it. The ones that talk about it with confidence, um, and ease are the ones that usually get retained.
The question that we passed over, I'm just going to read. If two experts are equally qualified, what's a subtle factor that usually breaks the tie?
Um, Sometimes it's location. They're just sometimes one person may have more testifying experience than the other person. If all those are equal, it could just be a likability factor. They just got along with the attorneys better in the interview. Um, Usually, unless the rates are, polar opposite, that usually doesn't come into effect. If they're around the same amount, $100 here or there is not going to make the difference. So I don't really see rates interfering unless the person, is unless they're polar opposites. Um, but sometimes being too low is kind of raises questions like, why is this person so much lower than everybody else? And being too high raises questions as well. So, if you're working directly with an attorney, you can just say, I feel like my rate is, in the market. But if you feel like it's different from the other people you're interviewing, talk to me about it. Let's have a conversation. If you're working with a search firm, and you can say these are my rates, but come back to me if I'm out of bounds, right? If I'm outside of the ballpark, I want to know. I want to make my rates more within the market.
Recently, I've been asked to send my CV and fee schedule or even my retention agreement and retainer fee invoice, and then the attorneys have ghosted me. What is the timing and recommendations for follow up to not sound too thirsty? Haha. Excellent
That
question.
um okay. So when I wish I could ask a follow-up question to this. When you've been asked, has it been on the telephone or has it been through an email from the attorney? So if it's on the telephone and you're talking, and you say, "Yes, I'll send my CV and fee schedule," it's fair to ask at that time, when is your timing to hire an expert? Because I need to check on my calendar to see if I have the availability. So if that's perfect, if they call you on the phone, you can get them and ask them that question. You could ask that question before you send your materials. Just say, I'm working on my materials, but a lot of times you'll do a conflict check. So, as part of my conflict check, would you let me know when you would like this expert to start? And, when I need to check my calendar to make sure I have availability to take this on. And that way you can kind of get the information up front and then you submit your CV and fee schedule, and then you can put in your calendar, all right, they told me they're going to want this person to start April 1st. This is now March 1st. I'm going to follow up in a week because they're going to have to interview that person in the next couple weeks. So if I don't hear anything by, let's say, March 10th, I'm going to follow up and ask if they need additional information.
They answered it was telephone, which you answered. So
Okay, great.
that's that's great. For speaker, highlighting means highlighting. Do not delete material from your CV. This can cause problems during depo or trial if there are other extant versions of CV.
Oh, so what you're saying is they may find another version of your CV.
That
Um,
doesn't have right, exactly.
yeah, that's something you can talk to your I would talk to the attorney about because if you if there's different versions up there, I think that's a fair thing to say, I can see where you're coming from. You can highlight it, but if you're I mean, I would just the clear answer is I've been in the industry for 40 years, and if I put everything on my CV, if I keep everything on my CV, it'd be 30 pages long, and so I update it for the most relevant material for this particular case. But if you want to see everything I've ever done, here.
Along those same lines, our next question. I've heard that tailoring CVs to matters can backfire if the opposing side highlights other versions of a filed CV or of a filed CV, which is a little bit of a different situation. Is there a way to ameliorate that issue?
Okay, so here's two things. We have a CV that you're giving an attorney so you get hired. This doesn't necessarily mean the CV that are on a file for you to be an expert witness. So if you're trying to highlight what relevant for hire you and you don't want to give 40 pages, I think that's a different CV than once you're hired and you're like, okay, here's everything I've done that I'm filing with the court. This is my standard CV. Um, we can file this so it's going to match. So that's one way to think about it. Or like if go ahead and use the same CV and just make sure you highlight what's relevant. And then it's a non-issue. You don't have to tailorize it because the least amount of work you do during the expert witness process is better for you because you're not getting paid. It's your own time. So use the same CV all the time. Just highlight it.
And finally, I was wondering where you see experts unintentionally overselling or potentially underselling themselves in their materials and or the interview.
At the interview stage. Well, if they undersell themselves in the materials, they're not going to get an interview. If they oversell themselves in the materials and they don't match in the interview, then they're not going to get the engagement. Um, so you, just be transparent, just be authentic. If it's a match, it's a match. Again, you don't want to get an expert witness position that isn't a match. So just be transparent. And then as far as the interview, if this is your expertise, you're most likely going to be passionate about it. Going back to my expert that was in the industry, it was about semiconductor chips. And this guy was so passionate about making waffle chips. I actually found it very interesting, even though it was a very dry subject. But he was extremely passionate about it, knew everything, the ins and outs. And those are really the slam dunk interviews. When you find the right case, you know everything about it. It's what you do. It's what, the questions are easy to answer because you can answer them in your sleep because you know everything there is to know about it. And those are the cases you're looking for.
Well, this concludes the Q&A section of today's webinar. I'd like to thank our guest, Monica Poole, for joining us here today. Thank you so much, Monica.
I really appreciate this opportunity. And so that's the last thing I'm going to leave with you. Just be authentic, just be yourself, and the right cases will come along, and you'll get the right assignments. So thank you, Noah.
Thanks again.